All right. Well, we're still 2 minutes shy of 11 o'clock. Give me 1 second. I'll just go ahead and log in.
Were you able to find that guidance also?
Still no LEPs, right, officer?
No.
Okay, thank you.
I'm going to position myself to the corner.
All right. This is the 11 a.m. initial appearance calendar for March 20th, 2026. The court's orders for the taking of fingerprints and DNA samples made on the 2 a.m. calendar on the 1st of this month will also apply to these hearings. Before I call the first case, I am going to read the victim's rights advisement, and that is that if you are the victim of a crime with a case pending before this court, you're advised that you have rights under Arizona law. Those include the right to be treated with fairness, respect, and dignity, the right to a speedy trial in the case, the right to be present at all court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, the right to be heard before the court makes any decision on release, negotiation of a plea, scheduling, and sentencing, and the right to receive restitution from a person who is convicted of causing you loss. If you've not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. All right, and then I want to get started with Mr. Marriott's case, number 10. If you'll come to the podium, that's going to be Mr. Torres, and I do think we have Mr. Brevington. You're in court for the Marriott case, right?
Yes, that is correct, Your Honor. Good morning.
Oh, okay, good morning. 1 second, let me get my camera working. Okay, right here at the podium, please, sir. And just give me a second. Okay, all righty, there we go. Okay, all right. Mr. Marriott, can I have your full name and your date of birth, please?
Sure. Mark Allen Marriott, May 26, 1977.
Okay, thank you. I'm just trying to get this to a point where they can see me. All right. Well, good enough for today. All right, to the appearance of the state, please.
Thank you, Your Honor. Brooke Gaunt on behalf of the state, and the victim is present and would like to address the court.
All right, I am aware of that. Thank you very much. And defense counsel.
Yes, good morning, Your Honor. Andrew Brevington on behalf of the defendant, Mark Marriott.
All right, thank you very much. Mr. Marriott, you have been arrested on the following allegations: aggravated assault by serious physical injury, which was booked. The police often make a mistake on the class of felony. They booked it as a class 4 felony. That subsection of the statute can only ever be a class 3 felony, so I have corrected that error. Criminal damage as a class 1 misdemeanor and disorderly conduct as a class 1 misdemeanor. Before the court addresses conditions of bail or release, Counsel Brevington, did you want to be heard on the question of probable cause?
No, Your Honor. While my client obviously has a different story and disputes some of these facts and allegations, on the face of the Form 4, I can't challenge probable cause.
All right, thank you. So I do find probable cause, and I've noted in my paperwork that as part of the court's finding, the court did refer to the National Institutes of Health website for the anatomy of rotator cuff. I cited the website in my order. And I am taking judicial notice of that. And counsel, did you want to be heard, Counsel Brevington? I tried to pick the most judicially noticeable website I could find, and it is from the National Library of Medicine and the National Institutes of Health. And any objection from either counsel on the court having referred to that website?
No, Your Honor.
Not from the defense. Obviously, we don't know enough about the injury to really, make any statements on it, but no objections to Your Honor taking judicial notice through that website.
Okay, thanks. And just so you understand, Mr. Mayor, it's because in the Form 4, they listed some very specific injuries, a full tear of a medical word that I did not know what it was. And so I looked at the website just to understand that they were referring to a shoulder and certain muscles, and it did very clearly say fully torn muscles. And on those allegations, the court believes that the element of protracted impairment of the function of any bodily organ or limb was met. It's a legal standard. It's a fairly high standard. And so, but I did, at least to my layman's understanding, based on that website and based on what's been alleged, I also considered the victim impact statement for that. And I do find that it qualifies, at least for purposes of probable cause at today's hearing, as the element of serious physical injury. So I do find probable cause for all three of these allegations in your case, Mr. Marriott. And Mr. Brevington, I looked like you did a limited notice of appearance. That's correct, right?
Yes, Your Honor. You know, obviously I only heard about this case last night. I haven't had the chance to speak with Mr. Marriott. You know, I've spoken with his wife. I anticipate I will be appearing from now on, but we obviously need to have a meeting and sit down and come to terms for that. So in these circumstances, I just do a limited appearance, and then I'll meet Mr. Marriott early next week, and I assume that I'll be in the case from there on.
All right. So, Mr. Marriott, I'm going to appoint the public defender for you because based on your financial affidavit, you would qualify. That's certainly subject to any retention of counsel. You're entitled to retain the lawyer of your choosing if you're able to do so. So the public defender will withdraw if somebody else notices in, but I am going to appoint the public defender at this time. All right, before I set conditions of bail or release and give next court dates, I'm going to hear from everybody one at a time. And the state, would you like me to start with you, ma'am, or the victim?
I can start, Your Honor.
Okay, go ahead, ma'am.
Your Honor, the state's asking for a $10,000 secured appearance bond. Mr. Marriott alleged...
Let me tell you one thing. Mr. Marriott, I need you to keep eyes front, please, also because we have the victim viewing room, so I just need you to keep eyes front, okay? I apologize, ma'am. Please go ahead. 10,000 secured, you said?
That's correct. Okay. Mr. Marriott allegedly physically assaulted the victim, causing a very serious injury to his shoulder, which did in fact require surgery, and it sounds like from the victim impact statement may require additional medical intervention. This offense alleged to have arisen out of a road rage incident. There isn't any information in the Form 4 that indicates that Mr. Marriott and the victim knew each other prior to this time, which of course gives the state even more concern that this was quite frankly seemed to be two people that didn't know each other, and the extreme level of violence that Mr. Marriott allegedly shown to a complete stranger is concerning. Additionally, in the Form 4, it indicates that Mr. Marriott had agreed to turn himself in to law enforcement at some point, I believe in early December of 2025, and he failed to do that. Even after he agreed to. We do acknowledge it doesn't appear Mr. Marriott has any prior criminal history, but again, given the serious nature and the level of violence that was demonstrated in this offense, we are concerned that he is a danger to the community and believe that that bond is appropriate. Thank you.
All right, thank you. Now I'm going to hear from the victim. And we got to make sure that we have the microphone unmuted, and I'm going to wait for the high sign. Okay, will you just tap the microphone, make sure we hear it? Okay, it's on. Please go ahead.
Good morning, Your Honor. I just wanted, I know that you read my impact statement. I just wanted to kind of go over it again, kind of what happened. It was an unprovoked attack. I was driving down the road, and the defendant decided that he was going to slam my car and try to pull me from my car. Tried to open my door, and as in the process, pulled my shoulder apart, complete tears, 3 of my 4 rotator cuffs. Had bone on bone. I had to go to a specialist. I've been to 2 surgeons. The specialist basically said that does shoulders. This is one of the worst shoulders that she's ever seen. So I'm in chronic, constant pain all day, every day. Nerve damage now. I'm in a sling every day, all day for 6 weeks. Can't sleep. This has severely impacted my way of life for no other reason other than me being at an art fair in Scottsdale. It's bad. I can't work. I've had to use up all my sick and vacation time for the surgery. I am allowed to work from home, but I can't do much because I can't sit there long enough to do my work. I know that the state has kind of went on about what, we're not really sure what happened, but wasn't much for road rage. He was getting in an Uber, and I went around the Uber, and he attacked me for no reason. I had no interaction with him or anybody he was with. I know that they asked for a $10,000. I would definitely ask for a higher bail or bond, excuse me, and ask that he be on some sort of electronic tethering. This man should not be in society. He's very dangerous.
All right, thank you for being here. And we're going to go ahead and remute the microphone now. I always like to test it. Will you hit it again? I hear nothing. Okay. All right. And then Mr. Brevington, sorry, I was looking next to your client. Please go ahead.
Yes, good morning, Your Honor. First of all, I'd like to thank
One second. Is the thing not working? The monitor's not working? We don't have any. Normally, counsel, we have a screen that you would be appearing on and everybody else could see you besides me, but I can see that. Does it take very long? Okay, hang on a second. My staff's just going to pop over there. My staff's going to pop over there and try to get it working, just so everybody in the room can see you also. Okay. Oh, I forgot. She can't get down on my side. She had to go all the way around. Okay, here she comes. You're not on camera. Don't worry. If it doesn't work in a second, counsel, we'll just go. Oh, is it taking an update? Okay, thanks. All right, I think it's working on an update, so we'll just go ahead. We might be able to get it working for the next case. All right, thank you. Sorry, Mr. Bravington, please go ahead.
You'd like me to start? Okay. Your Honor, first of all, I'd like to thank the victim for coming here and making a statement. I haven't had the luxury of reviewing the victim's impact statement, so I don't even know the gentleman's name, but, I appreciate him being here. I haven't had the chance to meet with my client yet, and obviously I'm still getting my arms around the facts, and now is not the time to debate the merits. But I will say that although my client deeply regrets his involvement in this incident, he and his wife, who was there and was a witness, dispute the facts. They have a very different story about what went on. Apparently, you'll notice in the Form 4, there's a mention of a woman crossing the street. That was Mr. Marriott's wife. And his position is that the victim nearly hit her with his car. Again, we're not minimizing anything that happened, and these are as yet unproven allegations. My point is that this was a highly aberrational incident that was triggered out of concern for his wife. That's the first fact there. My client is significantly disabled. He needs a lot of medication. He walks with a cane. As noted by the state, he has no criminal history. No convictions, a couple of old arrests. I would like to touch on the allegation that he failed to self-surrender. As I understand it, he was asked to come in for an interview and he declined that interview, as is his constitutional right. So I don't know if there was a misunderstanding or a mischaracterization in the Form 4, but that is my understanding of what happened. He has deep ties to the community. He's not a flight risk. There's no community risk of harm here, given the aberrational nature of this incident. Again, not to minimize any of the allegations and injuries. And he's retained counsel, and he's engaged in this matter, and he's fully able and willing to defend himself, which means he's not an appearance or a flight risk, which is the other thing that the court needs to look at here. I came today prepared to make an argument for OR release based on these facts, and I still think that that's an appropriate release. However, I do understand that pretrial services met with Mr. Marriott a short while ago, and he agreed to an ankle tether and pre-services monitoring. I do find that interesting, considering he's retained, and I was not in part of that discussion. I also find it interesting, given that the state did not ask for pretrial services monitoring. At the same time, if my client's agreed to it because he thinks he's going to get out quicker, I'm not going to unwind that, and pretrial services monitoring would allay any concerns that the court might still have about community safety and risk after I've given you these facts. So if OR is not possible, and I don't know if it is, now my client's accepted the tether, I would just ask for pretrial services monitoring. I don't believe there's a need for a bond because he's going to have a monitor on him. They're going to be tracking his location. He'll be back to court. So my suggestion would be either OR or pretrial services monitoring without a bond. Thank you.
All right, thank you very much. Mr. Maria, I've considered what's been alleged against you in what was provided by the police. I've considered the statements of both lawyers, the statements of the victim, and your criminal history. I do see the older arrests that don't appear to have resulted in convictions. So I've considered all of those things. And there are essentially three factors that a court weighs when setting release conditions. These come from the Arizona Constitution. And they are appearance for court, of course. The other one is community safety risk, and then the risk of victim or witness intimidation or retaliation. So I've considered all of those factors as well. And on these facts as alleged, the court believes that it is consistent with conditions it has set in other cases and individualized to you. The court is very concerned about the allegation that even if the court accepted the allegations as true and the victim may have come close to striking another person with a car, that what is alleged gives the court pause for your behavior out in public and the community safety risk of someone who it is alleged would have done something like this. The police alleged that at the time, and this is just in the Form 4, that you were under the influence of alcohol or drugs at the time. That sounds consistent with what has been described. But the court believes that a substantial but not overwhelming secured appearance bond is appropriate in a circumstance like this. If you had more criminal history, then the court would consider a much higher bond. But I think what the state is requesting is reasonable and the least onerous bond that the court should set in a case like yours to protect the alleged victim from potentially retaliation or witness intimidation, which can still occur, even though it hasn't now that the case is pending. It could, and this bond amount and my release conditions are intended to, they may not, but they're intended to cover the entire period of the case, both today and potentially many months from now, right through a trial, and seeing that a person who might suffer an adverse jury verdict surrenders for that verdict. So balancing all of that, I believe $10,000 secured is reasonable. And I also believe there is utility in an electronic ankle monitor, that the alleged victim is alleging very substantial injuries and targeting for reasons that were not apparent to him, and the court wants to be sure that you are staying away from him. I'm going to make you submit to drug and alcohol testing. You can talk to your lawyer about getting that lifted if it comes up negative. But on these facts, and it is a minimal allegation by the police that you were under the influence, but it is not inconsistent with the behavior that's been alleged and the location and time of your arrest in a bar district in Scottsdale, basically, or a restaurant district at any rate. So that is my order, $10,000 secured with an ankle monitor. Secured means you can use a bail bondsman. Don't have any contact with the alleged victim. I left it in as a her. It was because I often cut and paste. So I'm just gonna correct that real quick. It's a him. Don't respond to any contact from him. No contact with his family members or property. That's whether you are in or out of custody. If you get served with any kind of order against harassment, you have to comply with that as well. Don't go to the scene of the alleged crimes. No weapons, no drugs without a valid prescription, no alcohol. All right, everything's going to be on your paperwork. Anything else from the state?
No, Your Honor, thank you.
All right, and from the defense, Mr. Bradington?
Your Honor, just real briefly, I wanted to on the record, address the drug and alcohol counseling. My client left the scene. This is completely based on, I think, the victim's allegation that he was drunk. And our position is the victim was a lot more aggressive than what's here in the Form 4, that this was an incident of mutual aggression. So I don't believe drug and alcohol counseling testing is appropriate, but we'll address that later on, and we'll modify the release conditions upon, the initial test confirming. But I did want to get that on the record about that.
Okay, yes. Thank you, and fair enough, and Mr. Marriott, I do understand what your lawyer is saying, and so I'll just repeat what I said, which is, to the extent that you are testing negative, that will certainly support any motion to put a stop to that. And let me give you your dates. That's going to make your court dates a status conference March 26th, which is 6 days from now, 8:30 in the morning. That's a status conference in the downtown Superior Court. Then your preliminary hearing is scheduled for March 30th at 8:30 in the morning. The court address is going to be on your paperwork, and everybody here will be getting a copy of the order. Counsel, I believe we're going to email it to you.
Thank you, Your Honor.
All right. And thank you very much. Thank you, everyone, for being here. We'll be in recess on your case, and you're welcome to disconnect, Mr. Brevington. Thank you.
Mark, hang tight, and we'll be in touch after you get out.
Thank you.
Okay.
Thank you, Your Honor.
All right. Thank you. All right. We'll send out his paperwork too. Okay. Thanks. I fixed that, right? Okay. Yes, I did. Okay. All right. Let's go ahead with the Torres case. Mr. Torres. And after that, we need Mr. McAllister to the chair, please. Charles McAllister. All right, let me see. We have counsel. Great. All right. Mr. Torres, can I have your full name and date of birth, please?
Ramon Alexander Torres, December 30th, 1993.
Okay, thanks. The appearance of the state.
Thank you, Your Honor. Brooke Gone, back to the state.
And defense.
Good morning, Your Honor. This is William Wynn. I'm standing in for my colleague David Black on behalf of Mr. Torres.
Okay, thank you. And Mr. Wynn, the reason everybody's kind of looking that direction is because we now have the monitor working. They can see you, and you're over
perfect.
off to their right. Okay. All right. Mr. Torres, you have been arrested. Oh, I meant to correct this as well. All right. You've been booked in on one allegation of aggravated assault by the impeding of breathing or strangulation, which is a Class 4 felony under Arizona law. As I noted to the last defendant, the police often make a mistake. The aggravated assault classification is complicated, and they make mistakes on that all the time. So the aggravated assault section that you are accused of violating is always a Class 4 felony. So I've made that correction. And Counsel Wynn, before we go to release conditions, I am inclined to find probable cause on what was alleged in the Form 4, but I do want to give you a chance to be heard on probable cause if you want to.
Your Honor, much like the previous case, I believe we have some disagreement with the facts as alleged. However, the facts alleged in the Form 4, I do believe, support a finding of probable cause.
All right, thank you. Mr. Torres, based on what the police submitted for purposes of today's hearing, I do find probable cause in your case. You can talk to your lawyer. This is a finding of probable cause just for the purposes of today's hearing. It's not your formal probable cause finding in this case. So your lawyer can help explain all of that to you later. So I do find probable cause for today's hearing. And I'm not appointing a lawyer for you because you've hired Mr. Wynn's firm. All right, I'm going to give you your court dates in a moment. Before I do that, I want to hear the state's recommendations on bail or release conditions, please.
Thank you, Your Honor. The state's asking for a $25,000 secured appearance bond. Our understanding, it doesn't appear that Mr. Torres has any prior criminal history, but we are significantly concerned for the victim's safety, given that this is a domestic violence offense. He allegedly strangled her on 2 separate occasions over the course of this offense, and then threw her down. She did undergo a forensic nurse examination that did indicate several injuries that were consistent with strangulation. As the court is well aware, there is a high lethality associated with domestic violence strangulation, and because this is a domestic violence offense, we'd also ask for electronic monitoring to ensure the safety of the victim. Thank you.
And thank you. And counsel, did you see in there's of course the Form 4 that the computer filled out here, but there was the one that I forget what police department it is, but I think it's Goodyear. that they used, and it says the victim has since left the state of Arizona. Did you see that one? Do you have any information on that?
I don't have any information related to that, Your Honor.
Okay, all right, thanks. Go ahead, Mr. Nguyen.
Thank you, Your Honor. Mr. Black informed me this morning, he's in Coconino County, so I'm handling this for him. Mr. Black also let me know that his understanding was that the victim is in Utah with her family there. She's no longer in the state. Given that she is out of state, I don't know what electronic monitoring will accomplish here. I believe that a simple requirement that he not leave the state is sufficient. Your Honor, I'm asking for release to pretrial services. Mr. Torres hired Mr. Black about a week ago. A little less than a week ago. Mr. Black reached out to the investigating detective to try and arrange for a self-surrender. We never heard back. Unfortunately, he was arrested yesterday, but he was not evading arrest by any means. He was attempting to arrange for his own arrest. He has no criminal history, as the state mentioned. Additionally, my review of the Form 4 does suggest that although the SANE exam revealed injuries, I did not see that it revealed any injuries consistent with strangulation. I know that's a fine point, Your Honor. I'm not suggesting that nothing happened. However, given his lack of criminal history, the fact that he's hired counsel, that the victim is no longer in state, my understanding is also that the victim does not desire prosecution. Additionally, he resides in state. He's not a flight risk. There's no history of failures to appear. I believe that release to pretrial services is sufficient.
All right, thank you. Mr. Torres, I've considered what's been alleged against you, your lack of the criminal history, and the statements of both of the lawyers here today. And my decision in your case is to set bail in the amount of $10,000 secured, no ankle monitor at this time. And that is lower than what the state requested because you don't have any criminal history and because the Form 4 does not specify the listed injuries with enough detail for the courts to, evaluate where they might fall on the continuum of this type of injury. That being said,
Your Honor,
this
really
type of
briefly,
Go ahead,
I apologize. Much for the same reason that we're not asking for an ankle monitor, the victim is, by all information, out of state. The scene of the alleged incident is Mr. Torres's home. I would ask that he be allowed to return there.
Thank you. And I have drafted up a sort of an order for that, but we'll go over that in a second.
Okay, thank you.
No problem. So, Mr. Torres, the state remains concerned that it's true to say that the research on this type of allegation indicates that it strongly indicates an elevated risk of violation of release conditions and future violence. And I understand the victim is out of state. That's why a lower bail, but it is not remotely outside the realm of possibility that a person who committed this type of offense, if you did, is the type of person who would attempt to dominate and control the victim from another state or even potentially leave the state, would be more likely than average to violate release conditions if there is the type of a domestic relationship that resulted in a strangulation. So I believe bail is still very much required to prevent victim or witness intimidation or retaliation. Also, I want to make very, very clear, Mr. Torres, I am ordering no contact with her. That includes you may not respond to contact from her. If it's true that she had told somebody she doesn't support a prosecution at this time, that is separate from whether the state of Arizona goes forward on these charges against you. So the alleged victim may try to contact you. You are not permitted to respond. And I always make that very clear in cases where there's an indication that the victim may be the one to reach out to the defendant. The court believes that is not safe, it is not a good idea, and I am prohibiting it. So do not respond if she were to text you or call you or email you or show up at your door, because that occurred to me too. So what I have drafted is to say you may return to and reside at the scene of the alleged crime only if the alleged victim is not present or residing there. If she is present, or she returns to the home at any point while the case is pending, then you must immediately depart the area and find an alternative residence, provide proof to the court within 3 business days. So I'm not putting you on an ankle monitor, because if you want to leave the state to Utah, grossly violate release conditions, and do something terrible to this person, an ankle monitor won't prevent you. It'll, I guess, give some warning, which is maybe a reason to do it. I don't know. I'll think on that for a second. I'm also planning to order, which I have in many cases like this, a note that, to clarify, this order does not apply to any child you may have with the alleged victim. However, you may not violate this order in order to exercise your parenting rights. So if you're unable to figure out a way to exercise your parenting rights without violating the no contact order, then you won't be seeing your child for a window of time. It is not forever, it is for now. And nothing about your parenting rights will supersede this court's order. That's why it is in my order, because many people might feel justified or somehow that it will be accepted as an excuse. It won't. So you can talk to your lawyer about that. If you get served with an order of protection, you have to comply with that as well. No weapons, no drugs, no alcohol while the case is pending. So let me first hear from your lawyer. Do you want me to read that language again, counsel, about going to the house, etc.?
Your Honor, I think it was understood. It makes sense to me, and we can discuss it further with Mr. Torres if he has questions.
Okay, thanks. So essentially, Mr. Torres, if she shows up at your door and says, "Car's packed, I want to move back in," you have to politely close the door and arrange to get yourself away from her, that you cannot have contact with her. Simple, plain and simple. And if the police were called, they would read my order. You would get arrested even if she begged them not to. So let me hear from the state on all of this. Go ahead, ma'am.
Your Honor, I have no objection to that language regarding the residence.
Okay, all right. Then those will be my orders, Mr. Torres. That's going to make your court dates, a status conference March 26th at 8:30 in the morning, which is next week, and a preliminary hearing Monday, March 30th at 8:30 in the morning. Those are in the downtown Superior Court, and the address is going to be on your paperwork. We're going to get that paperwork finalized. You'll get a copy, Mr. Torres. We'll email one to you, counsel, and the state gets their own. All right. Anything else from the state?
No, Your Honor.
All right. And from the defense?
No, Your Honor. Thank you.
Okay. Thank you for your time. Have a great day. All right. You can go and have a seat, sir. We're going to send out your order. Okay. All right. Mr. McAllister, if you'll come to the podium.
Can I be excused?
Oh, yes, please. Yeah. Stay right there for a second, Mr. McAllister. I just want to get her out the door. Thank you. Okay, go ahead, sir. Thank you. And then after Mr. McAllister will be Ms. Ngala, Alyssa Ngala. All right. Good morning, sir. Can I have your full name and your date of birth, please?
Charles Vincent McAllister, 62490.
Okay, thank you. You are here on a new case and a warrant in your probation case, I believe. All right. In the new case, you are booked in for possession of both dangerous and narcotic drugs for sale. Those are both Class 2 felonies. Possession or use of a weapon during the commission of any drug crime. Possession of a weapon by a prohibited person, and simple possession of dangerous drugs. Those are Class 4 felonies. Based on what the police presented, there is probable cause for all of those. I am appointing a lawyer for you. And I'm appointing a lawyer in your, you already have a lawyer in your probation case. This is a failure to appear warrant from probation court. It came from a revocation arraignment on February 24th of this year. All right, so you should end up with the same lawyer for both cases. Right now, your court dates are slightly different. Nope, they are the same. You're lucky. Okay. So I can set the next court date for both cases. It's March 26th at 8:30 in the morning. That is this coming Thursday. That'll be a revocation arraignment in your probation case and a status conference in the new case. Then in the new case only, you will have a preliminary hearing, which will be March 30th at 8:30 in the morning. In the probation case, the court finds that you will, in all reasonable probability, be revoked to prison, so you do not have bail at all in your probation case. You're held without bond. In the new case, I believe the state's recommendation is appropriate, given your criminal history and the apparent strength of the evidence against you and the weapon. So it is set at $30,000 secured with written release conditions. But You shouldn't even try to post it if you're still being held without bond in your probation case. Everything I just told you is on your paperwork. If you please step to your left, the officer's got that for you. Thank you. All right, Ms. Ngala? And then Joe Lopez, will you go to the chair? Where is Ms. Ngala? Here she comes. And after that will be Joe Lopez. There's a chair just inside the door. Well, yeah, there you go. That's where I wanted you guys to be waiting. Okay, thank you. All right, ma'am, right here at the podium. Can I have your full name and your date of birth, please?
Alyssa Ngala, May 19th, 1989.
All right, thank you. You are here on a new case and a probation hold. In the new case, you were arrested for possession of both narcotic and dangerous drugs. Those are Class 2 felonies. Possession of a weapon by a prohibited person, a Class 4 felony, and possession of a weapon during the commission of a drug trafficking crime. That is also a Class 4 felony. Let me just double check one thing, okay?
Okay.
Okay. All right. There is probable cause for all of those, and I am appointing a lawyer for you. Your next court date is going to be a status conference March 26th at 8:30 in the morning with a preliminary hearing March 30th at 8:30 in the morning. Now, in your probation case, you're on probation for a Class 6 felony, and you were in warrant status because on June 3rd of 2024, there was a petition to revoke your probation filed alleging that you violated terms 3, 4, 5, and 7. You'll get a copy of that from your lawyer, and I am appointing a lawyer for you. Your next court date in probation court is going to be the same date as your new case. It is Thursday, March 26th at 8:30 in the morning. The address is on your paperwork. In the probation case, it will be a revocation arraignment and possible disposition hearing. In the probation case, the court finds that you will, in all probability, be revoked to prison, so you do not have bail at all in your probation case. In your new case, the court sets bail in the amount of $15,000 secured. You don't have nearly as much criminal history as the last defendant. You're in a very similar situation, though. But I'm setting bail in the amount of $15,000 plus release conditions in your new case. But you shouldn't try to post that, though, if you're still being held without bond in your probation case, because you wouldn't get out. Everything's going to be on your paperwork. If you step to your left, they're going to give you a copy. Thank you. Mr. Lopez? And then Sheridan Smith, will you go to the chair, please?
Hi, Your Honor.
Hello, sir. Can I have your full name and your date?
My name is Joe Lopez, May 8th, 1975.
All right, thank you. You're here on a newly filed case. You have been indicted by a grand jury. Let me double check. I thought this, no, let me see. No, this is a direct complaint, sorry. It's procedurally different, that's all.
What does that
Sorry,
mean?
no, wait a minute, I lied. It is an indictment. An indictment means a grand jury met. They heard evidence and they found probable cause to formally charge you with these two crimes: aggravated identity theft, a Class 3 felony, and possession or use of dangerous drugs, a Class 4 felony. The alleged offense date for those was back on April 10th of 2025, and what I can see from the warrant is this comes from the Mesa Police Department. But the grand jury proceedings and the indictment will become unsealed between now and your next court date, which is your arraignment hearing.
Okay.
You'll get copies of those charges and the police reports from your lawyer. Well, wait a minute. Right now it says you're not indigent. I am appointing a lawyer for you. Sorry, officer, we have to reprint this one. I'm going to appoint a lawyer for you, Mr. Lopez.
Okay.
And your next court date is going to be an arraignment hearing, which is what happens when you've been indicted. March 27th at 8:30 in the morning, which is 1 week from today, in the downtown Superior Court. And in this case, I'm going to affirm the bond set by the judge who issued the warrant. It is $25,000. It is cash only, with written release conditions that include no contact with any of the alleged victims. Now, what did you want to say?
Since then, I've completed counseling for drugs. I got my peer-to-peer certification. I just had twins a month and a half ago. My wife just had twins. I'm the head of the household. There's also 4 other children, so that's 6 children plus my wife. And I'm the one that was working. I got hit by a car 2 days ago. I mean, we're trying to work things through. And if I don't get released, we don't obviously have the money, $25,000, whatever it is, to get me out. But I have not been committing no crimes. I have not been doing nothing. I've been doing good. I've been a father to kids. I have two new babies that just appeared, you know, that she just had, and they need me out there. I'm just letting.
This is the court's concern, Mr. Lopez. You have at least 8 prior felony convictions.
Yes, I do.
And the court
people-
does not know what evidence was presented to the grand jury. I don't know. What I know is that a Superior Court judge heard about that and believed that a $25,000 cash-only bond was the appropriate bond. And you have so many prior felony convictions that your credibility with what you're telling me is reduced. Even if it were true, though, Mr. Lopez, the court believes that this type of bond in this type of case is not on its face unreasonable. There's never a good time to be rearrested. These crimes were alleged to be less than 1 year ago, and you have 8 prior felonies.
Since my father's death and since I've changed, okay? I've changed, and people do change. And you know what? I took these classes, and I've been very, very, very adamant to myself and on the point to do everything, not only for my kids, but for my family, is all I have. I stopped using drugs. I used to inject them.
Mr. Lopez, you shouting at me doesn't help the situation.
I know, but what I'm trying to get a point across.
Less than 1 year ago, you are accused of victimizing multiple people. Less than 1 year ago, and a grand jury heard evidence and has formally charged you, which means that it is not a small amount of evidence, Mr. Lopez.
It was just one person that had SMI, and she was
Sorry.
It was also shown to the
Mr. Lopez, you need to talk to your lawyer. I'm imposing this bail. Your lawyer could file a motion to modify.
For my children,
Please step to your left and take your paperwork. All right, Mr. Smith, after he goes out, you can come on in. All right, after Mr. Smith will be Heather Brieger, please. Hi, sir. Can I have your full name and date of birth?
Sheridan Oliver Smith III, 9/27/89.
All right, thank you. You are here on 2 probation warrants. Looks like you're on probation for 2 undesignated offenses. Back on March 5th of this year, a petition to revoke was filed in both cases. It alleges that you violated terms 3, 4, 5, 7, 13, and 15, including by failure to self-surrender for a jail term. I am appointing a lawyer for you on both of these petitions. Your next court date will be in the Downtown Probation Court, March 26th, which is this Thursday at 8:30 in the morning. The address is on your paperwork. Your bond in each case is $1,000 secured with written release conditions. You can talk to your lawyer about whether or not you can start getting credit from today on that self-surrender term, because now this is a new petition to revoke. But if you do bond out, it's $2,000 secured. If you do bond out, comply with all of your conditions and call your PO within 72 hours. If you step to your left, she's got your paperwork. Ms. Brieger, where's Heather Brieger? After that, Geraldine Carmen, we go to the chair. Hello, ma'am. Can I have your full name and your date of birth, please?
Heather D. Brieger, 11/24/82.
All right, thanks. You're here on 2 probation violation warrants. You're on probation in 2 different felony cases. No, I'm sorry. One of them is a pending case. Yeah. Let me double check here. Right, one's probation, one's a pending case. All right, in the probation case, on March 9th, there was a petition to revoke your probation filed. It alleges that you violated terms 3, 5, and 12. You'll get a copy of that from your lawyer. I am appointing a lawyer for you in both cases. And in the pending case, you failed to appear at a status conference on February 13th of this year, and there was a warrant issued for your arrest. In this case, you've been charged with theft as a Class 5 felony, and you already have a lawyer. So your next court date for both cases will be the 26th. In the probation case, it's that revocation arraignment. In this new case, it's a status conference, March 26th, 8:30 in the morning, with a preliminary hearing in the new case only, March 30th, 8:30 in the morning. Those are both in the Downtown Superior Court. In the pending case, I am affirming the judge's bond of $1,000 secured, and in the probation case, I am affirming the probation judge's bond of $250 secured. That is $1,250 total. If you bond out, comply with all of your conditions, don't contact the alleged victim in the theft case, call your PO within 72 hours. If you step to your left, she's got your paperwork. Thank you. Ms. Carmen, Geraldine Carmen. And then Larry Gates, we go to the chair. Mr. Gates. Thank you. All right, ma'am, can I have your full name and your date of birth, please?
July 19, 1983, Geraldine Carmen.
Okay, thank you. You're here on a bench warrant for failing to appear in a pending case. Looks like you were set to be sentenced in a case in which you were originally charged with possessing dangerous drugs, a Class 4 felony, and drug paraphernalia, a Class 6 felony. On March 17th of this year, you missed a court date and a warrant went out for your arrest. You'll get, so you already have a lawyer, so you're going to have a status conference in front of the sentencing judge March 26th at 8:30 in the morning. And you have a $500 secured appearance bond. I'm just affirming the bond that your sentencing judge gave you. You have written release conditions as well, but I'll let you read those. They're on your paperwork. If you step to your left, she'll give you a copy. Mr. Gates, and then Andrew Menard, we go to the chair. All right, Mr. Gates, can I have your full name and your date of birth, please?
Larry Aaron Gates III, January 29, 1990.
All right, thank you. You're here on a warrant in a case in which you have been accused of misconduct involving weapons, a Class 4 felony, back on June 17 of 2025. You missed a status conference. Hold on a second, I want to look at your criminal history. Okay. I need to reprint this one, officer. Sorry.
Can I say something?
Yes.
So with that, the owner of the weapon, she turned in a letter to the judge stating that the weapon was hers.
All right, sir, I'm not here to decide whether you did it. Even if what you're telling me is true, that does not make the case go away. Also, I'm looking at the docket. There's nothing in the docket, but even if there was, sir, it wouldn't change my mind. You straight up missed a court date last July and never self-surrendered. Your criminal history score gives you a maximum recommendation. You have 1, 2, 3, 4 prior felonies. None of them are drug charges: armed robbery, ag assault by temporary disfigurement, unlawful use of means, 2 convictions. So your criminal history is doing you no favors today. Mr. Gates, this is serious, and nothing that you told me changes it even a little. One more thing. Go ahead, Mr. Gates. I've
been waiting for to have something in the mail. I have not received anything in the mail.
No, sir, Mr. Gates, that is not remotely an excuse.
I have not received anything in the mail. My girlfriend's pregnant with my child right now.
Mr. Gates, this is happening. Okay.
I know.
2,500 secured is your bond. If you post it, comply with all of your conditions. You don't miss a single court date. If you think you needed something in the mail, you can call in. But defendants have to keep their address updated. You have 4 prior, sir. I don't believe for 2 seconds that you didn't know this was coming for you. You did 5.5 years for armed robbery. This idea of like, I just get to sit around on a gun charge and wait till they find me. You did not self-surrender. You've known this was coming. So that's your bond. If
I didn't receive anything in the mail.
It's not a thing, sir. Something in the mail. There was a court date set. You were physically present in court when it was set. That's your notice. Nobody mails you anything.
It was rough at that time.
I know. So you don't get a do-over, sir. It's not a dentist appointment. So you have a lawyer. You can go talk to your lawyer at the next hearing about convincing the trial court to trust you on some other basis. But this court, I'm not buying any of it, sir. You can try that with the downtown judge. 4 prior felonies, and sitting here May 12th, I'm going to look at your
But my girlfriend.
According to this, you were physically present in court when that court date was given out.
My girlfriend.
So go talk to your lawyer. Also, sir, there's no way that a person with 4 priors thinks that they were just in the middle of a felony case and then all of a sudden seems to just be over. I don't believe that for a second. You knew this day was coming.
I knew this day was coming.
So you didn't self-surrender, Mr. Gates. So the court has no reason to trust you. You're facing 10 years on this charge. You face a presumptive 10-year sentence. And so the court doesn't trust you. So we're going to get your paperwork printed. You can talk to your lawyer about a motion to modify.
I've been helping my girlfriend with my baby.
That may be true, Mr. Gates. There's never a good time to be arrested for things that you have failed to take care of.
I'm not a bad man.
I'm not saying you are a bad man. What I'm saying is I don't believe for 2 seconds you're going to voluntarily appear. That's what I don't believe.
I would.
I don't believe you. So if you'll step to your left, we're going to send out your paperwork. Good luck. Mr. Menard?
Well, how much was my boss?
$2,500. After Mr. Menard will be Austin Stinnett, if you go to the chair. Hi, sir. Can I have your full name and your date of birth?
Andrew Menard, 5987.
I'm sorry, say it again?
Andrew Menard, 5987.
Okay, thank you. You're on 3 things. 1 is from the Pioneer Justice Court of Pinal County. One is an arrest warrant from the Superior Court on a newly filed charge that actually is fairly old at this point. And I'll tell you all about it. I know about it, please. I know that there's been a lot of discussion. I got some statutory things I need to do. I will give you a chance to talk, not an open invitation to interrupt, because I've got to do some legal things, okay? So you're also here on a third warrant from the Santan Justice Court in Chandler. I'm going to start with your newly filed criminal case. I say newly filed, it's not that new. This warrant has been waiting to find you. So back on June 17th of 2022, there was a warrant issued for your arrest for charges that got filed from 2021. Those charges are possession of dangerous and narcotic drugs, both class 4 felonies, possession or use of drug paraphernalia, a class 6 felony. Those are all alleged to have happened on June 6th of 2021 out of the Mesa Police Department. You will get a copy of the charges and police reports from your lawyer, but it dates back to 2021, the original offense date. I am appointing a lawyer for you. Your court dates in the Superior Court for this case only are a status conference on Thursday, March 26th at 8:30 in the morning, with a preliminary hearing March 30th at 8:30 in the downtown Superior Court. Now, your warrant from Pinal County is number 6 on the calendar. In the Pioneer Justice Court, you have been charged with driving under the influence of alcohol or drugs while impaired to the slightest degree, alleged 2 different ways, and then they've also charged you with driving on a suspended license. That's a class 1 misdemeanor. This warrant has been outstanding since September 8th of 2021. It's listed as a failure to appear in the Pioneer Justice Court. All right. Your next court date in Pioneer Justice Court is scheduled for March 25, which is this Wednesday at 8:30 in the morning in that court, and the address will be on your paperwork. It's over in Pinal County. I don't know which town. All right. In Santan Justice Court, you have been charged with shoplifting, a class 1 misdemeanor. There was a failure to appear warrant issued for you on August 17th of 2021 after you failed to appear. They say it's the 4th warrant they've issued. You failed to appear July 22 of 2021. The original charge dates all the way back to 2017.
That's crazy.
And in that case, your court date is also an arraignment hearing March 25, 8:30 in the morning in the Santan Justice Court. Now, what did you want to tell me?
No, I was just, these charges are hella old, and I didn't.
Okay.
That doesn't matter. I know you got to face them, but.
Okay. All right. Yeah. So they don't sort of expire, particularly the DUI in Pioneer Justice Court. So your court date there is next week. Your bond in Pioneer Justice Court, that's the one in Pinal County. I'm just going to affirm their bond. It's $500. It is secured. In the shoplifting case here in Maricopa County, you have a $250 secured appearance bond. And in the new felony, you would otherwise have been eligible for release in the felony case. So what we do is we set what's called a placeholder bond, $50. So that is $800 total across the 3 cases. If you bond out, go to all of your court dates. There's 2 court dates that conflict on there, the misdemeanor ones. You need to get on the phone and call one of those courts and get it rescheduled if you bond out. If you don't bond out, Pinal County has to wait until Maricopa is done with you.
Okay, I just have a question. I don't know if you can I bond out from here? Now?
You can bond out from here on the Pinal case. You can. Talk to the DOs, but yes, I am 98% positive.
Right now, right?
Yeah, is that right, officer? He can bond out on the Pinal. I just gave him a bond on a Pinal misdemeanor. He can bond out from here, right? Yeah, okay.
So,
all right, step to your left, talk to them about bonds and fines. They'll give you instructions to give family and friends about where to send them to post the bond.
Okay.
All right.
So it won't be all here. They have to post here.
No, they can. No.
I'm sorry.
The DOs can tell your family and friends to go down to bonds and fines at some address. Like they'll, as far as I know, all the DOs can tell you what you should tell family and friends. Yeah, but after court. So ask her after court about what instructions to give family or friends about where to go. Yeah, I think it's in downtown Phoenix, right? Yeah, you don't come to this building. I think they go to downtown, but okay. All right, so the DOs could help you, but it sounds like you just send them down to 4th Avenue Jail. There's probably a sign.
They can pay and I can be out in a little while.
Correct, and then you don't lose that paperwork. It tells you where to be, and I'll just remind you, your Pinal court date and your Santan court date are the same. I can't fix that, so if you bond out, get on the phone to one of them and ask for a rescheduled court date.
If one of them for the DUI, I'm sorry to interrupt you.
Right.
Sorry, man.
It's okay. What's
Was
that?
one of them for the DUI?
Correct, that's
Okay.
the one in Pinal County.
'Cause that's a serious one, right?
Yeah, and so the number for the Santan Justice Court will be right there on your paperwork. You probably have to look up the Pioneer Court if you wanted to call them. But just call them and say, I'm double booked, you can prove it if they want to see it. But I believe those lower courts, especially, in the Santan one, who knows? It's up to them whether they give you a new date or not. I don't know what they'll do. I'm just warning you, it is the same date. So if you bond out, you've got to get one of those moved.
So all I owe, as you see, is $800.
Right, meaning that's your bond, but the cases are still pending. You know, if you bond out, you got to go to all the court dates.
Yeah, no,
Okay,
I know
okay,
that. I
okay,
just
okay.
didn't know, like you say that. I
Yes,
could've-
your
could've-
total is 800 for all three cases.
So I get on phone, boom, I'm gone.
Correct. Well, I hope you're gone until your court dates.
Yeah,
But,
but
okay.
yeah, that's what I mean.
You're
I got
gone
the
from
money.
this place.
I have the money, so that's what
Okay,
I'm asking.
okay, all right,
I
fair
have to
enough.
bond out right now. Okay,
Yes,
thank
sir.
you.
All
I
right,
appreciate
thank you. Good luck. Mr. Stinnett? All right, then Colbert Chischelli, we go to the chair after Mr. Stinnett will be Mr. Chischelli. Is Stinnett not ready? Okay, let's do Mr. Chinchilli. Let's do anyone who's awake. Can you go check on them, officer? I think we got sleepers. Officers, I'm looking for Stinnett and Chischelli. Okay, Stinnett all the way in, and then I need Chischelli to the chair, please. All right, sir, can I have your full name and your date of birth?
Austin Lee Stinnett, 3/20/1995.
Okay, thank you. You are here on 3 warrants. They're all for failing to appear in probation court, as I recall, yes. We failed to prepare a revocation arraignment January 23rd of this year, and there were warrants issued for your arrest. You already have a lawyer in all 3 of these probation cases. Your court date is Thursday, March 26th at 8:30 in the morning. That will be a revocation arraignment and possible disposition hearing. Okay, hold on. This is a new case. All right, so 24 is a probation case, yeah, for criminal trespass. Then 26 is a probation case. Okay, so 2 of your cases are probation. 1 of them is newly filed. So I misspoke, okay? So in your probation cases, your court date is this Thursday, March 26th, 8:30 in the morning, and you already have a lawyer. Now, the 3rd case, number 25 on the calendar, you've had charges newly filed. And so you've been charged in a criminal complaint with a new case. It's possession of narcotic drugs, a class 4 felony, and drug paraphernalia, a class 6 felony. The alleged offense date is November 12th of 2025, and it looks like they just filed these charges about 2 weeks ago. So you get a copy of the charges and police reports from your lawyer. I am appointing a lawyer for you in this case also. You should end up with the same lawyer for everything. In this new case, your court dates will be a status conference Thursday, March 26th at 8:30 in the morning, with a preliminary hearing March 30th at 8:30. Those will be in the downtown Superior Court, and the address is on your paperwork. Your bond in each of the 3 cases is $250 secured. It's $750 total. $750 secured. If you bond out, comply with all of your written conditions, and don't miss those court dates. Everything's going to be on your paperwork. If you step right there, when she comes back, she'll hand you your paperwork. All right, thank you. Mr. Chischelli? Did we not find him? How about Christopher Alessino? Did we not find Chischelli? Are they looking for him?
I guess she let him out, he's.
Oh, okay. All right, Mr. Alessino, you can come in. Right here, sir. Hi, sir. Can I have your full name and date of birth?
Christopher Alessino, April 13, 2001.
Okay, thanks. You're on a new case. You were arrested for failure to admit the carrying of a deadly weapon on your person or in a vehicle when asked by a police officer. That is a class 1 misdemeanor. There is probable cause for it. I'm going to give you a court date of April 9th at 9 in the morning. That's a couple weeks from now in the Highland Justice Court. The address is going to be on your paperwork. And you don't have any criminal history that I know of. They didn't list any in the Form 4. So I'm going to release you on your own recognizance. We don't appoint lawyers in this type of misdemeanor case. You have the right to hire a lawyer or just go and represent yourself. You can meet directly with the prosecutor, get discovery, talk to them about your case, or if you hire a lawyer, bring them with you on April 9th to the Highland Justice Court. Everything's on your paperwork, but you are released. I'm not prohibiting you from owning or possessing weapons because you don't seem to have any criminal history, and this is not the type of charge that goes with doing anything nefarious with the weapon, just not admitting that you had one. And so on that, I don't find a basis to order you not to possess weapons. You can.
Okay.
So everything's on your paperwork. If you step to your left, she'll give you a copy. Okay?
Thank you, Your Honor.
Sure. Mr. Lovato, Sergio Lovato, or Vergio, let me have Chischilli come in, Mr. Chischilli, and then Mr. Lovato, wait in the chair, please. Yeah, I forgot we got Mr. Chischilli back. Right here, sir. All right. Good morning, sir. Can I have your full name and date of birth?
Yeah, Cobra Chili, 51486.
Okay, thank you. You're here on a new case and a probation hold. In your new case, you got arrested for shoplifting as a Class 4 felony, meaning with 2 or more prior shoplift convictions in the previous 5 years. That's what makes it the Class 4 felony. There is probable cause for it, and I am appointing a lawyer for you in this new case. You're also here on a probation hold because probation department, by policy, they have to file a petition to revoke your probation based on this new arrest. So you'll get a petition to revoke from your lawyer, and I am appointing a lawyer for you. Your next court date will be the same for both cases. It's March 26th, which is this Thursday at 8:30 in the morning. In the new case, it's a status conference. In the probation case, it's a revocation, arraignment, and possible disposition hearing. And in the new case only, you will have a preliminary hearing on March 30th at 8:30 in the morning, and the address for that will be on your paperwork. All right, and in the probation case, you have a $250 secured appearance bond. In the new case, wait, let me double check something, sir, okay? Yeah, okay. In the new case, you would otherwise have qualified for release, but for the probation issue. So I'm going to set what's called a placeholder bond. It's $50 secured. It's there to make you eligible for credit for time in custody. So your total bond is $300 across the 2 cases. If you post it, comply with all of your release conditions, call your lawyer within 72 hours. Everything's on your paperwork. If you step to your left, she'll give you a copy.
I can't just get out over.
Correct. Mr. Lovato, you can go ahead and come in. And then Hayden Beckton, we go to the chair. Hello, sir. Can I have your full name and date of birth?
Virgilio Lovato, 11/14/1989.
Okay, thanks. You're here on a post-adjudication warrant, which means you've already been convicted in a case where you've been convicted of DUI, a Class 1 misdemeanor. This warrant was issued October 2nd of 2025. And as I said, it's a post-conviction warrant for failure to pay fines and fees or failure to comply with other, sentencing orders. It's not a failure to appear. So your arraignment hearing is going to be April 7th at 8:30 in the morning in the West Mesa Justice Court. And when I look at your case, I don't see that there's ever been a warrant issued for you before and that you've been to court many times. And it looks like you probably fell behind on payments or you did something and then missed some mailings. So you don't appear to be any kind of a risk of non-appearance. So I'm going to release you on your own recognizance. Go to court on that date. And your case has been going on forever, and it looks like this is literally the first warrant. So just go to court, and this doesn't happen again, okay? It's April, what did I say? The 7th at 8:30 in the morning, okay?
Thank you.
Everything's right there if you step to your left. All right, Mr. Beckton, Hayden Beckton, and then Edgar Diaz. Will you go to the chair? Hi, sir. Can I have your full name and date of birth?
Hayden Beckton, 03/09/2004.
Okay, thanks. You're here on a warrant from Desert Ridge Justice Court.
Yes,
You've
ma'am.
been charged with driving on a suspended license, and this warrant went out December 24th of 2025. Your next court date will be April 6th at 1:30 in the afternoon. That's about 2 weeks from now in the Desert Ridge Justice Court. I am releasing you on your own recognizance. This looks like a first failure to appear from a citation. This is how people find out what happens when you blow off a citation.
Yes, ma'am.
And so most people convicted of this offense, unless you do it repetitively, most people never do a single night in jail. You just did one. So you may never do another one as long as you go to court. And for most people, this is enough to get them to go to court.
More than
If that's not you, we'll see you back here, and you probably get a little bond on top of this fun experience.
No.
So be sure to go to court. I'm releasing you on your own recognizance. Have a nice day.
Thank
All
you.
right, thank you.
Thank you, Judge.
Take care. You too. Mr. Diaz, and then Oscar Solis, will you go to the chair? Hi, sir. Can I have your full name and date of birth?
Edgar Diaz, January 2nd, 1992.
Okay, thanks. Mr. Diaz, you're here on a new case. This is going to go out of Buckeye City Court. You've been accused of assault, disorderly conduct, and criminal damage, all as Class 1 misdemeanors. There is probable cause for them, and I'm planning to give you an arraignment hearing of April 7th at 2 in the afternoon in the Buckeye City Court. Now, I am prepared and willing to release you on your own recognizance, provided you tell me you will comply with my orders that you go stay somewhere else while the case is pending. You don't live where your brother lives. Will you comply with that? Okay, good. Then, so what I'm going to do is I'm going to order, don't go to the scene of the alleged crimes, except you can go on a civil standby if you bring a Buckeye officer with you to keep the peace. If there's other adults there at the residence, not your brother, who can pack your stuff and bring it to you, then you don't have to mess with a civil standby. A civil standby can just be kind of time-consuming and annoying. But if you need to go physically to the house to get your stuff, you have to bring a Buckeye officer with you. Just call the non-emergency line and request it. They'll want to see your paperwork to see that you do have permission though, so don't lose your paperwork. Don't have any contact with your brother. Other people at the scene, I'm not worried about. The victim in your case is your brother. No drugs without a valid prescription, no alcohol. You are ordered to stay sober while the case is pending. If you got served with an order of protection, comply with that as well. It looks like maybe the two of you are living with your parents.
Excuse me?
Are the two of you living with your parents at that
Just
location?
my mom.
Okay, so your mom could bring you your stuff, and then you don't have to go to the house at all or mess with waiting for the cop and doing a civil standby. You can call your mom, you can talk to your mom, it's not a problem. Just don't go to the house without bringing an officer. All right, will you comply with all the conditions I just gave you?
Yeah.
All right, then you are released. If you step too left, she'll give you your paperwork, okay?
Thank you.
Good luck, sir. Mr. Solis? And then Emmanuel Valderas, will you go to the chair? Hi, sir, can I have your full name and date of birth?
Oscar Alonso Solis, and then my date of birth, 06/05/97.
Okay, thank you. You're here on a new warrant, well, I almost said a new case. The police weirdly double booked you on the same warrant, but just for purposes of anybody listening to this recording, we checked into it with MCSO and MCAO, and seems very clear, nobody's disputing that number 23 on the calendar, PF 2026-110486, was an erroneous double booking of Mr. Solis by Mesa PD. It is not a separate case. The only case this court believes is validly in front of me today is the 2025 warrant. So I am issuing a no action order on number 23. Mr. Solis doesn't need a copy, but we could go ahead and give him one in case anybody ever asked him about it and said there was this other booking. I'm not doing anything about it because it does, we see this very rarely, but the officer did computer misunderstanding and ended up entering it as a second case. So anyway, so you're here today on an arrest warrant from starting with the Mesa Police Department. You've been accused in this case in a criminal complaint with aggravated driving under the influence of alcohol or drugs with a person under the age of 15 in the car. That's a Class 6 felony. The alleged offense date is back on December 20th of 2024. And as I said, this comes out of the Mesa Police Department. So you'll get a copy of the charge and police reports from your lawyer. I am appointing a lawyer for you. I'm giving you two court dates. The first is a status conference, April 2nd at 8:30 in the morning. That's 2 weeks from now. In the downtown Phoenix Superior Court. Your preliminary hearing will be April 7th at 8:30. All of that information is going to be on your paperwork. And this is a newly charged or filed case. You haven't missed any court dates in this case. The only reason it turned into a warrant is because the court did not have a working address for you to send you a summons. So we don't hold that against you. This is just the unpleasant way that you find out. And then we did, looks like, or I'm looking at the docket, we did try to send you a summons and it came back undelivered. So we don't hold that against you. So you don't appear to have any criminal history. That's my recollection. Let me just double check before I say that. Yeah, well, I'm not showing any criminal history for you besides this. So I'm releasing you on your own recognizance. You do have specific release conditions though, which are don't drive without a valid license. Don't possess or consume any alcohol from this moment forward while the case is pending, unless another judge gives you permission to drink. No drinking for you at any time. Even if you're sober and you have a valid license, you are ordered not to drive any motor vehicle with any minors in the car. No one under the age of 18. So if you have kids, You can be in the car as a passenger, but you can't be the driver. Do you understand the difference? Okay.
Yes.
And you can drive yourself and other adults places if your license is valid and you're sober, but just no kids right now, because this type of offense does result in injured and dead children.
Yeah.
I have had to do the IAs for those cases. So just comply with those things and come to court. Will you do that?
Yes. I will.
All right, then you are released. Please step to your left. She'll give you your paperwork.
Thank you.
Sure. All right, Mr. Balderas? All right, and then, officer, I'm going to make my house call records while we get ready to finish up, you know?
Good morning, Your Honor, if it's still morning.
It is, by 8 minutes, it is afternoon. Good afternoon, sir. Full name and date of birth, please.
Emmanuel Valderas, 07/19/1990.
Okay, thank you. Mr. Balderas, as I believe you are well aware, you are here on a probation warrant. You're on probation for a Class 4 felony, and back on February 13th, there was a petition to revoke your probation filed. It alleges that you violated terms 1, 6, 7, 15, and 16. You'll get a copy of that from your lawyer, and I am appointing a lawyer for you in the probation court. Your court date will be March 26th, which is this Thursday at 8:30 in the morning in the downtown probation court. That's a revocation arraignment and possible disposition hearing. And because the Form 4 states that you self-surrendered, I'm going to release you back to the supervision of your PO. So you did the smart thing, and you listened to him, and you came and self-surrendered. So I'm releasing you, but you still have to comply with probation. So call your PO within 72 hours of release. If you're smart, you'll call your PO, right away, tell them what happened, tell them you got released, and be compliant while these revocation proceedings are going on, okay? That's the best thing you can do for yourself.
So I'm being released?
Correct. Yeah, and so call your PO when you get out. Start being real good.
I am.
Okay. No weapons, no drugs, no alcohol. Your PO will supervise you for us. And this is your first petition to revoke. They're alleging a ton of violations, but it is your first petition to revoke, and you did self-surrender. So I'm releasing you, okay? Just call your PO within 72 hours of hitting the street, okay?
I did see a judge for a charge for 2019 that I
have a city case?
They gave me a $200 bond.
Oh, crap. Is it a pink piece of paper?
It's for 2019.
Are you going to be able to make bond?
Yeah, sure.
Oh, yeah, okay. Then I won't add any bond on that. No. Because if it was some big bond and you're like, nope, I'm stuck in jail.
It's a misdemeanor.
I give you a tiny bond in this case so you could get credit for time in custody. But no, if you can post that, you're released in my case. That's Phoenix, I can tell, the pink piece of paper. You still have to post any other court's bond, so any cities like Phoenix, yeah, you got to post that. In the felony case, you're released, meaning I'm not adding any bond to that.
Okay.
So just come to court on Thursday in this felony case, all right?
Okay.
All right.
On this one?
Correct. In my case, we're giving you paper. Separate from that, our paper is white.
And that's for the probation here?
For the ag DUI probation, correct. If you end up not being able to make bond, you got to get a family member to try to call your PO or something and say, Emmanuel's stuck in jail. Don't get a warrant for him next week. He's in the jail because I've released you. So the sheriffs will not take you to court. You won't be on anybody's transport list for this felony case.
So if I'm not able to pay the bond,
they won't take you to court, and it'll cause a warrant. I could put a $5 bond on you in the probation case if you want to be safe, but they'll have to post $205.
That's fine.
Okay, all right. I will do that because that way, if you don't, hang on a second, if you don't make bond on the 200, they will take you to court next week for probation, and it won't cause a warrant. Okay, so 1 second, $5. I'm going to put, let's see, placeholder bond, that's what we call it, placeholder bond set, because the defendant has $200 bond from a Phoenix Okay, so it'll say, this is also a message to the sheriff's office people. It's a placeholder bond set because you have a $200 bond from Phoenix Municipal Court that you hope to post but may not be able to. And so this way, whatever family member you talk to, tell them.
So if I miss the court, there's
at least there's $5 that'll cause you to get taken to court because you'll be on the transport list as in custody.
Thank you.
So just tell whoever might post for you, bring $205. All righty, everything's gonna be in your paperwork, we just need to reprint it, it does not change your court date, it's still next Thursday, 8:30 in the morning.
Okay.
Everything's gonna be on your paperwork, just give us a chance to reprint it, okay?
Okay,
All right, good luck, sir, good job self-surrendering.
Have a blessed
Thank
day.
you, you too. All right, I'm gonna do a couple house call records and then we will finish up. Okay, so officer, I've got Sarah Penny as a house call, and I know she was isolated as a potential danger to herself or others well before court. Does that remain true right now? All right, and with Mr. Farenthold, the report I got was that he started to become argumentative and combative with officers and disruptive while you were organizing for the court hearing. Is that correct? All right, so he got isolated. All right, then I will go conduct the initial appearances for Mr. Farenthold and Sarah Penny in person, in-house, immediately after this recording. I'll advise Vincent Farenthold. He's here on 3 warrants, and I don't remember if they're all pending cases, but in number 12 on the calendar, he failed to appear to status conference on March 12th. In number 13 on the calendar, it's a direct complaint, a newly filed direct complaint, charging him with dangerous drug possession, class 4, drug paraphernalia, class 6, with an offense dated January 4th of 2026. And the last one is also a bench warrant in a pending case. Wait a minute, he may be non-bondable in his new case. Hold on. Okay, let's see. Okay, all right, no, he's not no bond. Okay, all right. It looks like his initial appearances in the pending cases were in February of 2026, and the newly filed case that is number 13, we got it clear, right? Okay, all right. The newly filed case was alleged to have happened on January 4th, so he was not on release when that was alleged. Okay, sorry. So the last case is also a bench warrant failure to appear in a pending case. He's been charged with dangerous drug possession, class 4 felony, drug paraphernalia possession, class 6 felony, and he already has a lawyer in that case. So he's going to have the same next court dates for all 3 cases. It's a status conference March 26th at 8:30 in the morning, and a preliminary hearing March 30th at 8:30 in the morning, and the court is presently inclined to impose bail in the amount of $1,000 secured in each case for $3,000 total. With written release conditions, I will go over with him. All right. And Ms. Penny is here on a new case and 2 probation warrants, and the new case she got booked in for narcotic drug possession, of class 4 felony. And then in 34 and 35 on the calendar, these are probation revocation warrants. Back on November 20th or so, there were petitions to revoke her probation filed, alleging she violated terms 3 and 5, so she get a lawyer in that as well. Same next court date for everything, March 26th, 8:30 in the morning in the downtown Superior Court, and preliminary hearing March 30th at 8:30 in the morning for the new case, only number 36 on the calendar. The court's going to affirm the bond, and Mr. Uher, you can come up, Trent Uher, and so I'll just finish Ms. Penny. Number 35 on the calendar, I'm inclined to do a $2,000 secured appearance bond, number 34, $500 secured, and number 36, a placeholder of $50 secured for $2,550 total for Ms. Penny. And if anything changes when I go through those folks in-house, my final order will reflect the court's ultimate decision. I'm not going to update the recording unless I have a reason to do something that I need recorded. Alrighty, Mr. Ewer, can I have your full name and date of birth?
Trent Ewer, April 22nd, 1994. All
right, thank you. You are here on a grand jury warrant. You have been indicted. It looks like the indictment was handed down 10 days ago, March 10th. And you've been charged with 2 counts of sexual assault as domestic violence offenses, both class 2 felonies, 1 count of attempted sexual assault, also alleged as a domestic violence felony. The domestic violence designation is a legal status. That's a class 3 felony, and kidnapping, a class 2 domestic violence felony. And the alleged offense date for all of those is May 5th of 2024, and it looks like this comes out of the Gilbert Police Department. But you will get a copy of the indictment and police reports through your lawyer. I am appointing a lawyer for you. I know you have an open case, and I would assume you have a court-appointed lawyer in that case as well. Everything should end up with the same lawyer.
Okay.
And so in this case, you have to go be arraigned. That's going to be 1 week from today, which is March 27th at 8:30 in the morning in the downtown Superior Court. And I am going to affirm the bond set by the judge who issued the grand jury warrant. It is $75,000 and it is cash only. If you post it, then by law, I think you're already on an ankle monitor, but you have to be on this case as well. So you'd be on an ankle monitor in this case also with written conditions. Can't go to the scene of these crimes. No contact with the alleged victim or victims in this case. No weapons, no drugs, no alcohol, obey any order of protection, and the rest I'll let you read for yourself. All right.
Quick question.
Yes.
So we paid a $75,000 cash bond for the other case. There were like 12 counts on that. All those got dropped down to 1 count of voyeurism. We never got any bond reduction or anything because...
Did you file a motion for it?
Yes.
You talked to your lawyer.
Yes.
Well, then the court would have denied it, I guess.
Yeah, because I guess these charges were coming down the pipeline or something.
I should say so that doesn't really influence my decision or my understanding.
Right. So do we get that money back?
No, this is a separate case, so you need to talk to your lawyer about the overall situation in your case. So I see. So in the pending one, I still can't. Oh no, now I can see the docket. Sorry, I thought it might have still been sealed. So let's see. Right. So I see that. Right, the motion to modify went through in November, and the court looks like they had to have denied it. So I haven't opened it up to read any of this. So yeah, you need to talk to your lawyer about the total situation, and if your lawyer wants to make some argument, it sounds like looking at the charges in that case, these are unlikely to be consolidated for trial, meaning they are two separate cases.
Okay.
And so as far as what the appropriate bail amount is, considering all of that, I believe the trial court needs to make that decision, and there are victims' rights involved in all of that. So talk to your lawyer about sort of a global motion in both cases. The state can do their thing, and the court will decide. But right now, this court is not aware of what the underlying charges are, or understanding that a court denied your request to modify your bail last fall. I'm not going to do anything different today. Doesn't mean you don't have good arguments for that to make through your.
Yeah, I just didn't know if since I got taken into custody, that bail for the other case goes back.
So if you're stuck in on a bond you now cannot pay, whoever posted that original one can move to have it exonerated. Your lawyer will know about that, like how the bond poster in the other case could ask to have the money exonerated back to them, which would just mean you'd have to repost it again, meaning it doesn't, like they could get their money back saying, guys in jail can have my money back, in which case then you would have a total of $150 to post to get out again. So talk to your lawyer about all of that, and everything's going to be on your paperwork, okay? All right, if you step to your left, she'll give you that. Thank you. Mr. Sway, Thomas Sway? Hello, sir. Can I have your full name and your date of birth, please?
Hello, Thomas Kimball Sung Sway, February 22nd, 1979, 2/22/1979.
All right, thank you. You've been accused of two charges in this case. The first is indecent exposure to a child. That's a class 6 felony, or a person under the age of 15. It's not any minor. You have to be under the age of 15. But they do allege that, and it is a class 6 felony. Also, third-degree criminal trespassing, which is a class 3 misdemeanor. Based on what the police have provided today, there is probable cause, and I am appointing a lawyer for you. I'm giving you 2 court dates. A status conference, March 26th at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing March 30th at 8:30 in the same court. And I know you told pretrial that you intend to represent yourself, which with a formal procedure, a court can allow you to do, but we don't do that formal procedure at this court. If you want to make a motion to represent yourself in the next court, the public defender will actually help you make that motion. That's part of their job.
I would like to say something. I'd like to say something on my behalf.
Okay, go ahead, sir.
I have a motion already in progress, a federal coup.
Tell me what a COOP is. I don't know, sir. I've been a federal prosecutor, and I don't know what that is.
COOP.
What does that stand for?
It's case on well, a general term is case on official presidents. So
well,
I've had cases since 1988 from larceny and theft of siblings and
okay, so
Lutherans, Mormons, and Baptists
so can you
and
tell me what
siblings.
What are you trying to persuade me to
what
do?
I'm saying is there's no implication. I did not trespass. I did not expose myself to any type of underage person. Those are inaccurate. They're not probable. They did not have cause. I have the right to thoroughfare where I was at. They are lying. They are false.
And I understand that you dispute these charges.
For sure, 100%.
I understand that, absolutely, as people do. This court doesn't decide whether you did it, only whether the police have alleged sufficient facts
for
the case to go forward.
At least at trial.
Sure, and you are absolutely entitled to go to trial, have a jury trial on all of it. They have raised a sufficient accusation. You enjoy the presumption of innocence.
My mental amount that I share time with friends my age, I don't do sorts of those things that are claiming of the police.
Okay, and I understand. And they're not accusing you of trying to molest a child or anything like that. Just performing a sex act on yourself with a disregard for whether a child could see. So it is it's a much lower degree of seriousness. It's still a felony though, and you have criminal history. So on the facts as presented, the court believes that a bail is required to ensure the safety of the community.
Well, I have criminal history that's never been proven in trial from the accused that has ever been sufficient to claim it.
Well, they're not saying these were acquittals. And
well, as far as specimen and condition and actual what is proven of myself from what is at the time of a police intervention or stop is not sufficient for those conditions.
I'm going to let you talk to your lawyer about what probable cause
and the highest level of a case that has been submitted, it is me that is asking the court to dismiss based on bias and that prejudice and that it's not sufficient for what they are saying I have done.
This is not the trial court. We are an arm of the Superior Court. We are not the trial court. We are the initial appearance court, which is a magistrate court.
They weren't seeing me. I didn't do anything wrong.
I don't dismiss cases. This court lacks the authority to dismiss a case. And so we find probable cause or we don't find probable cause. And I have applied the law, and I believe there's probable cause. It's not a terribly high standard at this stage of the proceedings. It is not the same as the high standard that applies at trial.
Department that is null.
All right. Well, and you can examine all of that with the assistance of your lawyer, or if you're allowed to represent yourself, then you can take that up with the trial court. But at this time, the court is going to set bail in your case in the amount of $2,500. It is secured. If you post it by Arizona law, you must be on an ankle monitor because this is a felony that's alleged against you. A felony violation of Chapter 14 requires an ankle monitor. So you have to have the ankle monitor if you post the bond. You must not go to the scene of the alleged crimes. Absolutely no contact with the alleged victim.
Can you tell me where that was or is?
It's at a bridge. It was under a bridge.
Like an address?
They should have an address on here. It is at 65th Street and Main in Mesa. 65th Street and Main under a bridge at that location. So try not to go to that intersection.
Yeah, because that's not where I was anyway, so to be more accurate.
So that's where they're alleging. But everything's going to be on your paperwork, okay? And if you want to represent yourself, talk to the lawyer at the next hearing. They can help you make a motion to self-represent. and they'll take that up with the trial.
Okay, well, I'd rather rely on the state case as far as the public defense and the
Okay.
Attorney General's office.
Okay, understood. All right.
Yeah, that would be much better because I think they're much more competent and aware of actual technical explanations and differences, and said so as though as in so as much for what is the overall theme and matter of why I'm involved in a case hearing.
Okay, I gotcha. All right, fair enough. Okay, if you accept your list, you've got your paperwork. Thank you very much, sir. All right, and I already made the house call records about 10 minutes ago on this recording if anybody's looking for those, so we're just going to stand in recess until 2 p.m. this afternoon.